Hello all, welcome to the live session of Narayana IAS Academy. So for the day we've actually picked up a very important topic on generative artificial intelligence. Okay, so for this there are a lot of concepts that we need to understand. First of all, we need to understand what is this particular concept of artificial intelligence, and then we need to know what is traditional AI and how is it different from that of the generative AI that we will be discussing about. And also we will be discussing about what are all the legal complications as well as the challenges that are surrounding the governance of generative AI. Okay, and also this particular article is actually giving us certain measures that actually have to be adopted in order to navigate through these challenges that are posed by generative AI or the governance issues in order to tackle them effectively. Okay, so now we will be discussing about what is and how is the governance of generative artificial intelligence done in India, as well as artificial intelligence jurisprudence, as well as also we will be looking into what are all the different provisions like section 79 of the IT Act of 2000, as well as we have the data protection Act of 2023, all these things, and we can actually map this particular topic to GS paper 3 mains examination under science and technology, developments and applications of science in everyday life, and issues relating to IPR, that is intellectual property rights. Okay, so moving forward, it is always important for us to understand what kind of questions that the UPSC had actually asked previously. And if you see, in 2013 there has been a mains question regarding section 66A of the IT Act. So these kind of statutes, the regulations and provisions and draft rules which are brought by the government, all those are important for your examination, specifically for your mains examination. Now let us understand what this particular article is discussing about. Okay, so the article discusses the challenges as well as the legal complexities surrounding the governance of generative AI or the generative artificial intelligence, and this actually suggests several measures in order to navigate these particular challenges very effectively and efficiently. So first we need to understand what is artificial intelligence. Okay, so artificial intelligence is nothing but it is basically the pattern recognition. So I'll tell you what is this pattern recognition all about. First of all, if there is a PC, that is a computer, okay, so I actually feed vast amount of data into this particular PC, and here the PC actually utilizes a number of tools such as machine learning, then neural links, etc., in order to process this and to recognize a particular pattern on the kind of data that is being fed. And based on that, when I actually give a prompt is nothing but if I am giving it a command in order to, for example, if I am saying, okay, using this PDF you generate what are the number of students who have actually qualified for the examination or not. So if I am giving a prompt or a command, what kind of output it actually gives me. So this is what is artificial intelligence, or the basic principle on which this artificial intelligence actually works. Okay, so this particular artificial intelligence is of two types. First is traditional, and the next is generative. So what is this traditional artificial intelligence all about is, this actually works on a predetermined or an already fed amount of data. For example, if I actually feed the system about a chess game, it won't create a new chess game or new rules. Okay, so it actually gives me output only based on the predefined set of data that has actually been fed. For example, so this is what is traditional, this one. And next, moving on to this generative, as the name suggests, it generates new data, it generates new dimensions for me, and also new images for me. from the data that I actually feed into it. So I hope you have actually understood what is artificial intelligence, the basic principle on which it actually works, the rules or the algorithms that is actually given, how does it actually process and give us the output, and based on that it is classified into two. One is traditional, that is actually that functions on the predetermined or the predefined set of rules of the data that it is actually processed, and the next one is generative, and for which are the examples of ChatGPT. The next is an example of BARD, etc. Okay. Now let us actually understand what is generative AI again. Let's quickly read about it. So generative AI, also called as generative artificial intelligence, involves the AI systems that automatically create the text, create images, audio as well as the video content. And unlike the traditional AI, which focuses on pattern recognition and predictions, this generative AI produces new content or new set of dimensions it actually gives you, and these systems are trained on vast data sets that I actually feed into the system and use machine learning in order to understand and replicate the patterns in human generated content. Example is ChatGPT as well as BARD. So though this actually seems very technical, what is very important is to understand the basic principle or the concept under which this artificial intelligence or generative AI works. Now, why are they saying that? There are a lot of legal complications and challenges that are actually revolving around how the governance of the generative AI is done. So that we will actually understand under three heads. Okay. So first one, we'll be discussing about this particular safe harbor provision that is actually mentioned in section 79 of the IT Act. The next one, we'll be discussing about the privacy concern, and next one is the copyright challenge that this particular generative AI actually faces. Okay. So first one is safe harbor and liability fixation. This is nothing but, for example, if there is an internet intermediary, these are the lines, terms that you need to know. What is an internet intermediary? It is nothing but the social media platforms or e-commerce platforms like, you have Instagram, Facebook, Twitter, Amazon, Flipkart, etc. What happens? These platforms are actually protected under this particular safe harbor clause, where they are actually not accountable for the kind of content that actually goes on their platform. For example, if I actually generate some content which is actually very sensitive with respect to that of religion or the ruling government or whatever it is, and if I post it on the Instagram or on the Twitter, and then if it actually becomes very sensitive, what happens? However, only I am accountable for it, but the platform is actually not accountable for it, and this has been upheld by the Supreme Court as well. So this is actually one of the challenges, and also we need to know that there is no proper demarcation on what is a user generated content as well as what is this AI generated content. That is also one of the challenges. Okay, so first we will see safe harbor and liability fixation. So here traditionally, if you see, the internet intermediaries, these are nothing but the entities that host the content created by others. Entities means these are your Facebook, your Insta and your other e-commerce platforms. Okay. So these have always been enjoying this particular clause of safe harbor protection. So these protections actually shield these platforms from liability for user generated content as long as they meet certain due diligence requirements. What are these technical terms? Is nothing but if the government goes to the platform and asks which is the user which posted this sensitive information, then they will actually give back the details about this particular person who has actually posted. Okay, so this is what it is. The next one, the landmark Shreya Singhal judgment actually upheld the section 79 of the IT Act, reinforcing these protections. So what does section 79 say? This is prescribed under the IT Act is legal immunity that outline the intermediaries, that they actually enjoy the protection against the content that is posted by the users on their platform. This is very, very simple. Now, what is the associated challenge that they face? Applying safe harbor principles to GAI tool is very, very complex. Why? Because sometimes these tools are actually looked upon as the intermediaries, okay, similar to that of the search engines. That is, they are just looked as a platform which generate data, okay, they themselves cannot think. And while others see them as mere conduits for user prompts, that is, I give it a prompt and it actually gives me a data. So in what way is it accountable for that kind of a sensitive information or news? That is what is the question. Next, following this, the Delhi High Court's ruling in Christian Lawbotton SAS versus Nakul Bajaj 2018 case complicates this further by stating that safe harbor applies to passive intermediaries, referring that the entities functioning as mere conduits or passive transmitters of information. Now moving on, distinguishing, as I already told you, what has been user generated, what has been platform generated is actually not there. So it is very, very difficult to place a governance law or a piece of legislation. Next one, also if you see, in June 2023, a radio host in US actually had filed a lawsuit against the OpenAI, that is ChatGPT, saying that ChatGPT had actually defamed him. That is saying that this particular person was a narcissist or a fascist or whatever, a religious extremist, etc. So he was actually offended it, and this is also a problem because there is no ambiguity, okay? So there is ambiguity. The ambiguity is classifying the GAI tools whether as intermediaries or whether to treat them as conduits or active creators will actually complicate the ability of the courts to decide who is exactly responsible for this. Now the second one is copyright conundrum. So this is actually nothing but, copyright is nothing but, for example, if I am the author of a book, I actually have the right to claim my particular content under this Copyright Act, okay, of 1957. But the question here is, if there is something, if there is a book that is authored totally by this OpenAI or the ChatGPT, or I use ChatGPT in order to give my book, whether that can be copyrighted or not is again a challenge, okay. So we will see. Under Section 16 of the Indian Copyright Act of 1957, copyright protection is only available as specified within the Act, which traditionally does not account for the works that have been generated by AI. Okay, so it does not include any kind of AI. And the 161st Parliamentary Standing Committee report underscores that the current Copyright Act is not equipped to handle the AI authorship and ownership. What are the challenges? Here the gap in the copyright laws prompts critical questions. What are these questions that are, that actually comes to us as challenges? First one, should existing copyright provisions be revised to include AI generated work? That is, this existing law, should it actually be amended or revised in order to include AI authorship also? In case if that is there, should there be mandatory co-authorship? Okay, so if I'm giving a totally AI generated work, will that be copyrighted? Or in case if that is not given, should it be given by a human author as well? That is, should there be a mandatory co-authorship with a human? Moreover, who should hold the copyright, whether ChatGPT will hold the copyright or whether I will hold the copyright? That is also a question, or a combination of both of us will have it. And additionally, the responsibility for copyright infringement by AI remains unclear. So, but however, if you see, ChatGPT in its terms and conditions had actually transferred all the blame and other things on the user, okay, so for any kind of illegal output that is actually generated, and this further complicates the issue. The last discussion is the privacy concerns, okay. So here we'll be discussing about two important terms, that is the right to erasure and the right to be forgotten. This is nothing but, once, for example, if I'm creating a wedding invitation using all my personal details, my address, etc., and once if I actually unsubscribe or withdraw my consent, will the data be erased or not? Will it be forgotten or not is the question, okay. So the Digital Personal Data Protection Act 2023 in India established strong privacy protections, including right to erasure and right to be forgotten. And this particular privacy jurisprudence is actually upheld by the Supreme Court in 2017 under the Puttaswamy judgment. So this actually laid a very, very strong foundation on right to privacy as enshrined in Article 21 of the Constitution. Now it is important to understand what is this erasure and to be forgotten. This particular right allows individuals to request the deletion of their personal data when it is no longer necessary or when they withdraw consent. And similar way to be forgotten also. So once they are actually not using it, it has to be forgotten. But what is the challenge here is, generative AI introduces new privacy challenges, because once you train the generative AI on a set of information like my personal details, my address, my wedding date, venue, etc., the absorbed information cannot be unlearned by the GAI. Okay, and this raises critical concerns about how individuals can exercise control over the personal data when it is embedded within the AI models. And also, this already, there is already issues regarding the privacy concerns with respect to that of the government, but now this GAI further adds to it. So that is what is actually being said. So now, what are the steps? Given that we've actually looked into all the concepts, now what are the steps to address these legal complexities is what we need to answer. Here, the author actually says that first there has to be a temporary immunity. That is, you need to actually test this particular GAI or the OpenAI in a controlled environment. That is what is called as a sandbox approach for GAI platforms, granting temporary immunity for the liability. Next one, there has to be data rights as well as responsibilities, where they are actually legally they are complying, and there are proper licensing as well as compensation for intellectual property used in the training models. And finally, licensing solutions are actually there, where you need to develop centralized licensing platforms similar to the stock photo websites to streamline access to necessary data for the developers, and also ensure that the data integrity against historical bias and discrimination. That is nothing but these are actually simple things. That is, there has to be immunity, there has to be, you have to be legally complying to that, and then easy licensing solutions must also be given. This is what is actually saying. And to conclude this particular topic, the jurisprudence around generative AI is evolving, we know that, but this actually requires constant as well as timely re-evaluation. This is very, very important, where revision of laws is actually required. So, we need to have a holistic approach and judicial interpretations. These are very crucial to maximize the benefits while safeguarding the individual rights as well as their privacy. So with this, we've actually come to the end of the live session by taking up one of the interesting topics of generative AI on how it actually functions, etc., and what are the governance issues and hurdles that is actually surrounding the same. So for more updates as well as more live sessions, please do like, share and subscribe to Narayana IAS Academy YouTube channel. Thank you and have a good day.